I go get busy with that saw. I just organized the trucks. Lots of room in there now.
Hi, everyone. Aaron Day here from Invest Offshore. Uh, we are just about to go live. Bear with us if you're just arriving. And it's how to invest offshore with an EB-5, specializing in China, from China into the USA. We had published some articles on this particular topic, and the author of the book brought to you by FATCA, Lon Fairbrook, he's going to join us on this webcast. And we have a special guest from Arizona. He's an asset protection specialist, and his name is Michael Figueroa, and he's going to join us from Arizona. And these two are going to share some information about how to help high net worth individuals from China and other countries use the EB-5 visa investment program into the United States. But we really have a footprint in China with helping this niche and through of our Hong Kong affiliates. And the reason that we've put such a focus on this is Chinese investors are going global. The outbound investment is already over 600 billion, and Chinese parties are expanding their businesses into new markets overseas. The country's investors often incorporate structures in offshore jurisdictions when they invest overseas. The most commonly used offshore jurisdictions include Hong Kong, naturally, British Virgin Islands, and Bermuda. Indeed, more than 60% of all Chinese outbound investment is concentrated in these territories. Cayman and Bermuda companies alone represent over 70% of the companies listed on the Hong Kong Stock Exchange. In British Virgin Islands have been allowed to list in Hong Kong since the end of 2009. So BVI companies are also listed on the Hong Kong Stock Exchange. Now, with the increase in Chinese overseas structures, it will not be a surprise to see a corresponding rise in disputes involving these structures. Parties need to understand the jurisdictions in which they have chosen to incorporate or do business with, and the various tools that can be used and steps that can be taken to give them an advantage in any dispute that arises. Offshore structured disputes, in particular, can pose additional challenges to the parties involved. So it's important that they properly position themselves and make use of the available tools to ensure that any victory is a hollow one. So today we bring you two experts in a live discussion about how to use the EB-5 visa program to invest into the USA from the PRC. I've got to make sure, for some reason, I'm going to make sure that our guests are joining us. We'll use a different method. And just bear with us, we're getting ready to roll in hopefully 2 minutes. All right, so how to invest into the USA from China using an EB-5 visa immigration program. It's called, ultimately, US always has their own names. Well, I can see Lon has joined us.
Yes, hello.
Lon Fairbrook. Now we're just waiting on Michael Figueroa. All right, so we're almost at the top of the hour. We're just waiting on one presenter to join us, and we have Lon Fairbrook on the line with us. Today's topic is how to invest into the United States from China using an EB-5 visa. And I provided a little bit of background on this. So in many cases, there's an uncertainty as to the reporting requirements, and that's somewhat about what this discussion will be about. And it's the application of the U.S. tax rules primarily that we're focused on. And it's related to the tax treaties, but the plans, and it has a lot to do with employer contributions, what's taxable as a compensation. Some of the real detailed questions are related to the foreign bank account report, known as the FBAR, Form 3520 as well. Ever since FATCA was enacted, these forms have been the real tough questions that we get are related to the various different tax forms. And today, one of the keys to this discussion is how to be exempt of these forms and what they are and how they've caused problems for other people, which we've been helping people unravel this now for months. But basically, okay, I believe that, yes, Michael has joined us.
Hello again.
Hello, yes. Michael. All right, so Michael, thank you very much for joining us. I've given we started a little bit early here today, as you're probably aware, and it's right now just reached the top of the hour. But I gave a brief overview about, the Chinese outbound investment, which is already $600 billion. And you just sort of touched upon the structures that are commonly used for Chinese high net worth individuals and Chinese family investment, and that Hong Kong is very popular. British Virgin Islands, as of 2009, are now able to be listed on the Hong Kong Stock Exchange. And Hong Kong Stock Exchange is 70% of the listed companies are from either Cayman or Bermuda. So we've seen a lot of these overseas structures used in the past, and Lon Fairbrook is with us as our expert, and Lon's written a book that's really itemized one of the things that we're talking about today. Is we like to think of it as the Shanghai through train, and and there's a white paper. This it's available on FairbrooksAlliance.com, all about EB-5 investment programs, and Lon spoke in Hong Kong on a couple of occasions and as a keynote, and was on a tax panel actually of a family investment conference in Hong Kong, and all Chinese families, mostly family offices. So we've been in communication with Michael, and we thought this was a great advantage today to open this up as a live discussion. And we're all learning, so bear with us, because we don't even know exactly how well this will turn out. But I want to introduce Michael Figueroa, and Lon is on deck to speak with the two of you, and I'm going to pass it over to you. And thank you very much for joining us today.
Okay, thank you.
Welcome. Glad to be here.
So I take it I should open the question that I've reviewed with you, Aaron, and in regards to Lon's book, which I'd like to mention that here. And the book is titled "The Carte Blanche Hard to Tax Deferred Investing and Asset Protection Overseas." And what I'd like to mention is, as both of you know, my area of expertise is in utilizing United States pension plan law and how to administer that for the benefit of clients that need to utilize those type of entities in their investment planning. And one of the points that I read regarding Lon's book deals with what's called Section 402B, and it deals with what I understand to be how foreigners can invest in pension plans and what the ramifications are both tax-wise and internationally in regards to reporting requirements that is necessary or mandated by both the U.S. government and other governments. So before I go into a series of questions, would Lon please give me and maybe the audience a bit of a background on what 402 is and a little bit behind your book on these issues?
Okay, well, sure. Well, as you know, the 401k is just right before 402b, but they are considerably different. One is the 401k only allows for U.S. status, thinking of doing investments, buying investments from offshore or from outside the United States. It obviously isn't going to work with a 401k plan. It also doesn't work if you're working and living overseas to contribute to a 401k plan, because it does not allow for cross-border transfers. So that was why in 1986 the IRS came up with the 402b, because more and more people are living and working overseas, and they would still like to have some type of a retirement plan that meets IRS rules. The big difference between a 401k and a 402b is not just one number. It's actually they're totally different. The 401k is a qualified plan, meaning that it's qualified to take a deduction at the individual level. A 402b plan is saying if you touch your money now, you pay tax now. If you touch your money later, you pay tax later. So therefore, it's not a deductible contribution. It's, well, the best way to call it would be it's an excluded contribution, because if the IRS has a way of determining that it's your money now, then you would pay tax now. So the better way to look at it might be to compare it to an award program. If your employer decided to set up an award program for the employees based on your performance, satisfactory service, all these other kinds of elements, they might be willing to maybe, possibly, give you a sum of money sometime in the future, not a direct dated time, but sometime in the future, then that might qualify to be an exempt from income plan, exempt from income now plan. So there are two different areas of the
So
law.
let me go to this part of it. I am currently working with certain people who need what's called an EB-5 visa. My contacts primarily Chinese nationals. And of course, under an EB-5, if you invest $500,000 or more in a qualifying business that employs Americans, 10 or more Americans per 500,000, you effectively get your green card. And
Yes.
most Chinese want their children to be able to go and work in the U.S., go to American universities, and be able to go back and forth without restriction. Now, what I'm looking at is investment programs, projects, and opportunities for the Chinese to invest their funds. And so, looking at your articles that you've written, if there is a way to set up a retirement plan that the foreign person could invest in, the advantages I could see are substantial. especially on an asset protection and non-reporting basis, if that is allowed, and per your
Yes.
paper it is. So if I was to compare and say the typical American can set up a 401k plan, his employer, which may be him because of the situation where he is the participant, the trustee, and also uh, the plan sponsor. So if that person sets up a company, sets up a 401k, any contributions that are made by the employer entity to the pension plan is a tax deductible expense.
Yes.
Any income that investment in the pension plan earns is tax deferred until such time as he's allowed to take withdrawals, generally age 59 and a half. And if by chance any of those participants, employees, should get in trouble where they had to file a bankruptcy or were sued because of personal guarantees, credit card debt, etc., no creditor can touch their pension plan asset. So in comparison to that, I am very interested in understanding how a foreigner can set up a similar plan and how that could move forward to be able to mirror what I've just expressed that's allowed to American investors using a 401k. So let me ask you to go from there.
Well, let's begin first with, I think China is a very good example because the People's Republic of China has much the same code as the IRS does in the fact that they're going to tax the Chinese on their worldwide holdings. Their worldwide income needs to be reported. They even have a passive foreign investment company ruling similar to the U.S. that if you're not working at a foreign company, that you're earning income from a foreign company, that needs to be reported on a special form. So if we're talking about an EB-5 investor, let's move him before he receives the stamp in his U.S. visa stamp. So at this point, he begins, he's only a PRC tax resident. He has no tax connection to the U.S. He's filed his paperwork in the EB-5 program, but the waiting line is about 2 years. So while he's waiting for 2 years, he's not subject to U.S. tax. He's not subject to U.S. tax until he actually receives the stamp in his passport. So at this point in time, all his tax issues have to be related to China. Now the advantage to the 402B is the 402B requires a foreign trustee. The administrator of the plan is a foreigner, the foreign country. It's a foreign plan. So already we've put the foreigner into a foreign plan overseas. It's not a 402B yet because he's still a citizen of China. So what we want to do is we want to bolt together his foreign retirement plan into the IRS code 402B, so that when he does receive the visa stamp, the IRS recognizes that as an occupational retirement plan and therefore gives it all the benefits of tax deferral and asset protection that a 401k plan that you mentioned has. So the first step is we need to move his qualified assets into a regulated, registered, recognized by the Foreign Account Tax Compliance Act and by the IRS, has a Foreign Account Tax Compliance Act identification number that says this is an occupational, we recognize this as an occupational retirement plan. So his contributions to that plan are based on the rules of China because he's not a U.S. person yet. So this is all has to be done before he becomes a U.S. person. So that's, now once he becomes a U.S. person, now he's in the U.S., he forms a company, He might well want to have a 401k plan for his U.S. employees, maybe for himself. But all that 402b plan was all his foreign retirement plan system. But its interfaces exactly with the IRS code. Then the IRS recognizes all of his assets in that plan are not subject to current tax because they're all tax deferred. So the Foreign Account Tax Compliance Act has a special recognition for occupational retirement plans that are recognized by the IRS, and that's on form, the FATCA form, as considered a limited conditional. In other words, they are not exposed to the Foreign Account Tax Compliance Act. They're exempt from reporting because they're deemed to be compliant because they have a government-regulated, registered, recognized plan administrator. They're not just some entity that someone set up somewhere. So that's really the basis of it. So all of the work on that foreign person needs to be done before he receives that stamp into his passport.
Now, the consultant or person that's competent to do the necessary processing of that, who have you found, or how do you find someone that understands those rules? Is that the typical immigration attorney that deals with an EB-5 applicant?
Well, the difficulty is that most U.S. tax attorneys are U.S. tax attorneys, and this is not tax law. This is foreign occupational retirement plan law. It's a completely different path. It's a separate path from tax law. Just like the 401k plan allows for deductibility, it has its own rules separate from tax law. The same is true with the 402b. It's on a different path. So you need to find an attorney who is knowledgeable on foreign occupational retirement plans and is able to then determine if that foreign occupational retirement plan meets the IRS code for a 402b plan, which means the plan has to be a plan where if you touch your money now, you pay tax now. If you touch your money later, you pay tax later. It has to meet that qualification.
Now, when you're talking about tax, when you touch the money now, you're talking about liability to pay both U.S. tax and, in the case of a Chinese national, taxes to the Chinese government. Is that correct?
The plan needs to be workable on both sides. First, it has to be workable from the China side, that it meets the China rules where you're not touching it now, you don't pay tax on it now. So that's first. Then when he becomes a U.S. person, it has to meet the U.S. rules, Section 83 rules actually, that it also is not touch it now. You see, a 401k is actually a touch it now plan. It's a qualified plan. It's vested in you. It's your plan. Nobody can take it away from you. It's a vested plan, and that's why it's called a qualified plan. The 402b is called a non-qualified plan because it has nothing to do with individual deductibility. It can't have anything to do with individual deductibility because it's not yours now. It's not yours until you get it.
So, in regards to that, I'm looking at a section of your book, and one of the things that was of interest to me, because I, of course, do not practice in this area, is the item where you bring up the Shanghai through train.
Yeah.
So if we're going to look at China and Chinese persons who are looking to get their EB-5, of course we can also understand that it could be from any other country, India, the Mideast, anywhere else, the same rules would apply. But let's focus on the Chinese issue. Can you explain to me a little bit more about the Shanghai through train process? What you mean by that?
Well, basically, there's a exchange control law in China that does not allow more than 50,000 US dollars to leave China. So if all of a sudden a China person wants to invest 500,000 in the U.S., how does he get his money out? He can only move $50,000 at one time. Well, what the Chinese have done, and I've heard this from many, many people, is they get 20 of their relatives to each move $50,000, and then they come up with, you know, $1 million that's outside. That's how they've done it, which isn't exactly, you know, in the rules. So what is in the rules, what is in the law, and it's been in law most recently, just actually since this past summer, is if the movement of money out of China is a contribution to their foreign retirement plan, to the China's regulated, registered, recognized foreign retirement plan, which happens to be in Hong Kong, then any regulated broker-dealer in China can move as much money of that person that he wants into his foreign retirement plan in Hong Kong. So that's how he moves his money out. Now the money's in his foreign retirement plan in Hong Kong, and now he can invest it in virtually anything in the world, and he decides to invest it in this project in the U.S. And he goes to the U.S. immigration attorney, and the immigration attorney says, "My goodness, where is your money coming from?" And so he says, "Well, it's coming from my government-regulated, registered, recognized retirement plan right here. It's recognized in the Foreign Account Tax Compliance Act with this particular ID number, and it's recognized in the laws of both China and Hong Kong as being deferred income, and it's exempt from reporting under W8 Ben E Box 29E, which is a foreign recognized retirement plan. So there's no foreign financial account reporting at the foreign financial account level." So that's how it's done.
So it seems so much better, easier, and less risky than to utilize the relatives and friends issue.
Yes.
That
Well, it's a huge liability. Let me give you an example. In 1994, I was calling on private Swiss banks to encourage them that if they had American clients, that they should structure them tax compliantly. And typically, the private bank would say to me, "Why should we do that?" Or attorney sets up an offshore company for them. Well, they weren't actually asking the U.S. person, "Are you filing your taxes on that offshore company? Are you filing your passive foreign investment company 8621 form? Are you filing your 3520 every year?" They didn't seem to be asking that question. And all of a sudden, some years later, 107 of the 450 private banks in Switzerland were sued by the IRS, had paid millions in fines. One bank was just recently sued over 100 million. This was just a few weeks ago. And they were all doing that because the IRS saw them as hiding money for Americans. See? So now let's take that same example, and we take a PRC person going to an immigration attorney in San Francisco, and the immigration attorney says, "Well, okay, tell me about your money." What verified proof does that immigration attorney have that can tell him that that money is clear, clean money as far as the PRC tax code is concerned? Because if the money's outside the PRC, how did it get there? And where has it been sitting? And has he been reporting that income in the PRC taxes? How does that attorney answer that question? Probably the same way the private banker asked the question. How am I to know? But who's going to be liable? The IRS considered the private banks liable. Why wouldn't they consider that immigration attorney in San Francisco liable if all of a sudden he immigrated to the U.S. and then it was the Chinese government discovered that he had 10 million of unreported income out of the Cayman Islands? Huh? And then all of a sudden the immigration attorney says, I didn't know about that. He didn't tell me about that. Oh boy, who's the IRS going to be coming after on that one? Well, I would have never guessed they would have gone after the private banks in Switzerland. Why should they be responsible for U.S. persons paying their taxes? So the point I'm trying to get to is the immigration attorney has huge liability exposure if he doesn't have something that protects him, something that ring fences that client away from his liability. And the perfect ring fence for that is a regular government regulated, registered, recognized foreign retirement plan that's recognized in the Foreign Account Tax Compliance Act, that's has a category in the IRS tax code. Then the pension administrator is the person that would be liable if there's something wrong with that, not the immigration attorney, because he would say, well, the government regulator recognized by the IRS, identified by Foreign Account Tax Compliance, has given me the proof that that's where the money came from. And of course, it would be more logical to assume that it would be deemed compliant if it came from a government regulated plan that's recognized in China and in Hong Kong than if it came from just a verbal from the client sitting in the San Francisco attorney's office.
So it seems to me what you mentioned is if we have a trustee of the pension plan entity that is keeping the records and filing the necessary forms, you have one source, rather that one qualified source that most government agencies would say is credible versus having stories being told that would not be credible and cause delays and other problems in the investigation phase of determining whether the money being invested is effectively clean money versus...
That's right. Yes. And the IRS pre-qualifies that because the pension administrator of the plan that I'm talking about is authorized to sign a W-8-BEN-E Box 29E. So that's a pre-authorization by the IRS that this administrator is deemed compliant. He's government regulated, he's licensed, registered, recognized, he's being audited annually. So the IRS is comfortable with that, and they've given an identification code that he can now sign the W-8-BEN-E. So it means that they're compliant, and they don't have to reveal his assets because they're in the plan.
So going to that situation, my clients, let's say coming from Shanghai, need to find this type of qualified government approved trustee. Yes. How do you find such a person or company?
Well, of course, then you can find it from me because that's what I do. But you basically would just have to you could theoretically contact all the registered pension administrators and ask them if they have this registration. It's called a limited conditional registration currently with FATCA. You'd call them up and say, do you have a limited conditional registration or do you have a GIN number? If they say they have a GIN number, then they're not qualified. They have to have a limited conditional registration. So if they have that and the ability to sign the W-8-BEN-E, Box 29E, then you know you found the administrator that is registered and recognized by FATCA and the IRS.
Now you did mention that this is something, this is a service that Fairbrooks and Associates does. So if I wanted to utilize your services in regards to this, how do you charge for such services?
Well, I'm glad you asked that because Fairbrooks Alliance is not a broker-dealer. We actually are the marketing arm for the pension administrator. The pension administrator happens to be a trustee that's a law firm, and the rules and laws of Hong Kong prevent law firms from marketing or advertising. So they aren't out waving a banner, and attorneys normally don't go knocking on doors or walking up and down the street looking for clients. So basically, I'm paid by the administrator of the plan. There's no separate fees or layering of fees. I'm just the marketing arm of the administrator of the plan, because that's how, as you said, how do you find people? Attorneys are sitting in their offices, they're not looking for anyone, and so I saw this as an opportunity many years ago that that people would be needing this service. So that's why I'm working with them.
Now, also in your book, you mentioned, and in articles, numerous articles, you mentioned all the compliance requirements of FATCA and other requirements, and that may or may not relate to what we were talking about regarding pension plan issues. So if a foreigner just wants to invest money in the United States in what I do, which is defaulted loan portfolios or foreclosed properties that can be bought under cost and way under market, what process would that foreigner go through, and would it be prudent for the person to contact you and you would be able to guide them through the maze of what has to be done?
This is a really, really excellent example that you brought up, because I mentioned earlier that China actually investigated the IRS and went home with the IRS documents in the 1990s. And they based a lot of their tax code on the U.S. tax code. So let's take a U.S. person, and he goes to France or Germany or some other foreign country, and he invests his money. How does the U.S. treat that? The U.S. treats that as a capital investment. He's not working there. Therefore, he needs to file a passive foreign investment company income. He needs to file 8621 and pay 36.9% tax on it annually. Oh, it's pretty ugly. And that's the form that all the people at the private banks weren't filing, you see. And the China person has the same problem. If he invests outside of China, then how can you be sure that he's telling the Chinese tax authorities about that? It's the same problem. You know, you might say, well, I'm not responsible for knowing that. Well, the private banks in Switzerland could have said the same thing. They weren't responsible. I mean, after all, he should be paying his taxes. So the big problem is the money clear from China, and is the person clearly reporting that to China if he's still a Chinese resident taxpayer? That's where the problem lies. So the wise thing to do in order to protect your own liability would be to have the PRC client place his investment through the foreign retirement plan that I've been talking about. Because then the foreign retirement plan issues a W-8BEN-E, which releases you of all responsibility from that client.
So let me go to this question. What are the restrictions for the foreigner to establish this pension plan entity? Is there an age limit? Is there an employment? Are there any restrictions? Give me a scenario of the typical person you've seen and they say, I want to do this. Do they have an existing company in China or around the world that they then say, this is a good plan for me to consider utilizing now?
Well, of course, in every situation, that's why the administrator is a law firm. A legal basis needs to be determined for every client, because it needs to be a contribution to a retirement plan, not a capital injection. There's a difference between a capital injection and a contribution. The three things they need for contribution is there must be an employer, there must be an employee, and there must be a contribution. So basically the first step would be, who's the employer, who's the employee, and what about the contribution? How is that going to be structured? So that would be the legal basis of establishing the plan. So typically, if you're working with a wealthy Chinese investor, they might already have their own company with profits and all of that sort of thing. And so you would actually just set up a plan for their own company, because this is a non-qualified deferred compensation plan. You can restrict the members of the plan. You don't have to have everyone participate. It can be limited to just the directors or the managers, the top people, your champions, whoever it is. It can be restricted. So all of those details need to be determined by meeting with an attorney. It's not a product that it's not a packaged product that you buy off the shelf. In fact, there's no foreign retirement plan that has a 402B automatically bolted onto it. It has to be done. And there's only 3 countries in the world where it's even possible to bolt a 402B tax code on the local domestic foreign retirement plan. So it's not available everywhere, and so that has to be sourced. So that's basically it. And again, I think the nice part about it is because it is a exempt contribution plan, it's different again from a 401k, because a 401k is a deductible at the individual level plan, and therefore there's cap limits of what the government says, what's the maximum deductible you can take at the individual level. This is not a deductible plan at the individual level, and therefore there's no caps. If you're looking for caps, you've got to look in the U.S. because this is there's no caps on something where it's not a deductible at the individual level. The goal is that if the foreign company laws allow the foreign company to make a capital deduction of the contribution, then it's really perfect, because the company gets to deduct it and the employee doesn't get to count it. And that's the ideal situation, and that depends on the country law regarding the employer's deductibility, and that can vary.
Now, looking at the exemptions, when you utilize this form of plan, I see from the documentation in your paper and book that when the plan invests in some project, it is deemed to be effectively similar to an accredited investor that is exempt from securities laws and other reporting that is normally required by an entity that would be investing in a project, which I can see this would be really advantageous for someone who would say, I want to invest these proceeds in transactions without having to report to anyone what I have, and a substantial area that I think, because I practice in this area, is being exempt from court orders and court appearances in litigation.
Yes.
Do you want to expound on that a little bit and give us some ideas of what you have seen and what the benefits are?
Well, from your standpoint, if you're providing the investment, your client is not the individual in the plan, the member of the plan. Your client is actually the retirement plan administrator. He's the account holder, because if it was in the individual's name, then it would be taxable because he's touching it. So the administrator is the account holder, and the administrator is an accredited investor, and the administrator is a pension administrator, which is not securities law, it's pension law. So therefore, there's no securities law regulations that's controlling what he invests in. It's totally pension law. And your account holder is not the individual members, it's the pension. You only have one account holder, and maybe you've got 500 sub-accounts, in that retirement plan, or 1,000 or 10,000, but you only have one client.
I see. So effectively what you're saying is that the investor is not the party that owns the asset. Oh,
exactly.
Okay. It is the pension plan and the administrator that is the party. And okay, I understand.
It's very important to understand that the employer has made the contribution, but under the laws, the statutory laws that this plan is registered under, the employer can never get the money back, because the money's no longer on the employer's books. It's only on the books of the pension administrator. That's very important. And that's why there's no, you can't bring a lawsuit against the pension administrator, for lack of, for bankruptcy or for some other reason. He doesn't even show up at court. It's just totally ignored.
That is an excellent issue because I dealt with that in civil litigation here in the United States. But now the other thing to understand is that the accumulation of the earnings is not taxable to the participant until they start to draw their money out. Is that correct?
Yes, that's right. Because you see, it's not theirs until it is theirs, and when it is theirs, then it's subject to their tax situation at that time.
Okay, I understand.
Yes. So.
Are there other issues that you feel that would be of interest to a person like me that I have not mentioned regarding utilizing this type of plan that I may not have thought of because, again, I haven't dealt with some benefit that we haven't covered?
Well, I'll give you an example of someone I met the other day. He's 69 years old, and his wife is 42 years younger. All of their assets are in a 401k plan or IRA. I think maybe part of it's in the IRA, which means that very soon he will have to make forced withdrawals of that money, and they have no other assets. So I can easily predict that when, with just normal life expectancy, since she's 40 years younger, that they're going to run out of the money by the time she's retirement age, So the benefit of the 402b plan is there's no forced heirship. And the benefit of this foreign retirement plan that we're specifically speaking of is the plan is in perpetuity trust. So it doesn't even have to close down upon the death of the member. It can actually just continue on and on throughout the generations of the family. So from an estate planning point of view, it's exempt from estate taxes, and it can continue in perpetuity. And for some people, that could be very important. Because, as I say, this person is forced to take money out whether he wants to or not and pay tax on it or otherwise. And I just can visualize that this poor lady is not going to have anything left in his account by the time she's retirement age.
Okay, to invest and earn money based on what is in the account at this time.
Yeah.
Now,
so I think it's an excellent estate planning vehicle as well.
one of the other things I'm looking at some of the notes I've taken. Explain, you have a regulatory path that's fully reporting on a continuous basis versus a path that is not reporting until a certain event occurs. Can you explain the difference between these two processes?
Well, for example, if you own a foreign investment account, I mean, you have a passive foreign investment company outside the U.S., you have to file on that each and every year. If you have your money in this foreign retirement plan, you don't have any special filing forms because the administrator just annually signs off on the W-810E that we have no reporting obligations regarding whether we even have or do not have U.S. people in our plan. So from the individual standpoint, he has no reporting on this.
Okay.
And he has no reporting continuously until, of course, he takes money out, and he has reporting.
So, in summary, in a way, what I've now learned is that this type of 402b plan can be established by a foreigner by engaging a offshore trustee through, most likely for the Chinese, it'd be Hong Kong. Yeah. And that once this is capitalized, which is not a deductible expense to the employer, but the earnings in the plan become non-taxable until they're drawn out. The plan is, or the funds in the plan for the benefit of the foreigner or the employee, I should say, is exempt from judgment creditors, bankruptcy, trustees.
Yes.
It is protected from litigation processes,
Yes.
which is very good.
You don't even have no disclosure, nothing. There's no reason to go to court, no reason to meet about it. I think it's important to just review that one more time. There's 3 phases. There's the contribution phase, then there's the middle part where it's growing, and then of course the good part when you withdraw the money. The contribution phase is made by the employer, and in the ideal situation we want the employer to be able to take that as a business expense or a deduction, so that he has some taxable advantages to making that deduction as a contribution. From the employee side, the contribution is excluded from his current income because it's not his. It's been passed over to the retirement plan administrator. It's off the books of the employer. And while it's in the hands of the administrator, it grows without any tax consequence. No tax reporting, no tax consequence. Then at the third phase, the good part, when he takes the money out, then it's subject to being taxable. It's not always taxable, but it's subject to it at that point in time.
Let me clarify something real quickly. The initial capitalization of the plan, the contribution by the employer, under a 401k, that would be a deductible expense to the employer. Did you say that this can be structured so that the employer who capitalizes the subject plan that you're speaking of, the 402b, can be a deductible expense to the employer?
Yes, it can be, but again, an attorney needs to look at each country and each company to see whether it's going to work for them. But that's the goal. The goal is exactly the same as the 401k. We want the employer to be able to take the deductible. We call it a deductible business expense because it's not going to the employee. It's going to the plan administrator under the benefit agreement. So that's what we want.
So again, all that is excellent. One other thing I didn't touch on was, what was the timeline that the employee must withdraw money? Again, under 401k, it's 70 and a half years of age. What is it for this plan?
There's no age. There's no there's no forced heirship. You see, if there was a date, then the IRS would recognize that as a vested plan. So there really can't be a date. There's no date in the documents, and the trust in Hong Kong is an in perpetuity trust, so there's no date anyway. So there's no period of time where they have to take withdrawals, ever.
Okay, I understand that.
Yeah.
And again, in order to establish such a plan, contacting your offices would be a start for the ability to obtain the necessary qualifying attorney that would understand how to start the paperwork and be able to do this. What is the timeline that it takes for getting such a plan approved and processed so that it can be capitalized from day one?
The timeline can be really short, but it can be complicated depending on the financials of the individual. If the individual has 3 or 4 companies and all kinds of complications financially, it's going to take longer. If the person is just simply an employee, let's say he's an airline pilot working for one of the airlines, and he wants to set up the plan. He's just an employee, employer, very straightforward. You know, it can be set up in a day. You know, it's not really difficult. It's just very straightforward financial. But if it's a businessman, he owns 3 or 4 businesses, and some are multinational businesses, I mean, it could get really complicated. We had the most complicated plan that I've seen involved 76 companies. It took 4 months, and the attorney fees was $42,000. But that's the absolute worst. I mean, that's really that's the extreme case.
Okay. Well, I can't think of anything else that I should ask you on this issue. Again, would you please restate the name of your book and how it can be accessed?
Actually, I think it's best if people go to my website. They'll understand who Fair Alliance is. We're not an employee-based company. We're actually a network of attorneys, tax advisors, financial service providers, family offices that have knowledge of the occupational retirement plan laws, and therefore they can introduce their clients to experienced legal counsel. And so the book, therefore, is really for the Fair Alliance members. If a member tells me, send this to my attorney or this attorney or that person or that individual, we send them a book, but the book is not actually for sale. It's just for distribution by Fair Alliance members. So and the other reason is that we send the book out in a PDF format because the IRS seems to have a tendency to want to change laws. They changed the 457A law in June. They changed the self-employment law for hedge fund limited partnerships. They changed that in September. In March of this year, they upgraded the Section 6038D regarding how to file the 8938. So I'm constantly wanting to update the book. It always has a date on it, and then if I know since I know who has the book, I can constantly send them the updated version. So that's really important because if some law changes, I don't want somebody having an old book out there, using the old rules. So.
Right, that makes sense.
Yeah.
That's excellent. Well, I can't think of anything else to mention at this time. Is there anything, again, that I missed or that you should mention that would be of interest to our viewers?
Well, I think the most important thing is to realize that this is all codified in law. Sometimes I have someone come along and say, well, this sounds like such a good idea. I think probably the IRS will stop it. They won't want this to be going on anymore. And so my answer, I always like to answer that question. It's one of my fun questions to answer, is because, first of all, the plan starts with a foreign employer. And when I say foreign employer, it means he's not a U.S. tax employer. He's a foreign employer. So he's not following U.S. tax law. He's following foreign, the employment law, employer law of the country where he's at. So he opens up a benefit service agreement with a plan administrator to make contributions to a retirement plan that are not owned by the members. So let's say one of those members is a U.S. person. It's not his money. So if the IRS came around and said, look, we can't have this 402B plan anymore, actually nothing would change because the employer's money is now off his books on the plan administrator who's foreign, and he's a foreign company. And then someday in the future, the plan says, oh, you can have this money. This is your money now. And the person takes the money out. What's the IRS going to say? You can't have the money? Of course. They're going to say, yes, you have to report it. But of course, he always had to report it. So the law never changed anything. So I hope that I made that clear and didn't muddy the water on saying that. But I think that's important, is if the law changes or not, it doesn't make any difference because the money's not the person until he receives it. And when he receives it, he's got to report it, just like everybody else that receives income that's a U.S. person. So nothing changed.
Very
good.
good.
In the meantime, he has a lot of conveniences because he has a foreign administrator. The investor is not a U.S. person, and many, many, many foreign investments will not take a U.S. person. So you have 23 trillion of funds in Luxembourg, and every one of those funds will have in their prospectus no U.S. person. Well, the administrator is not a U.S. person, so he can invest in those funds.
That's correct.
So that's why this carte blanche idea came up, because, well, why do you have carte blanche? Because you have no U.S. person restrictions, restraints, or blockage overseas, because your account is not a U.S. person account. It's a foreign, it's a foreign administrator of a retirement plan account. who's a professional investor, accredited investor. So that's what gives you freedom to invest the way you want. And because there's no annual reporting, because it's tax deferred, you don't have to worry about a PFIT problem, 3520 problem, you know, any of those other problems that create just money for tax filers. So I think that's my in the summary.
Very good, Lon. Well, I think we're done. Again, I thank you for your time, and I look forward to the next webinar that we will be doing with you on expanding other areas that relate to what you do.
Okay, excellent. I look forward to it.
Yeah, thank you both. Thank you both very much. Yeah, this will probably be put on a replay page, and well, we'll see how well it turns out. But we also might make a few short, but definitely would like to have you both come back. And I know I want to have another webinar at some point with Michael to discuss the idea of in real estate investment in distressed properties. So, you know, I have readers on Invest Offshore that are very interested in that topic as well. So hopefully we'll have some more webinars in the near future, but thank you both very much,
thank you.
Look forward to seeing you again.
Okay, good night.
Bye now.